This is TLV1.
The Tel Aviv Review. Hello, and welcome to the Tel Aviv Review, a program dedicated to the word, to the thought, and to debate, brought to you by the Van Leer Jerusalem Institute, which promotes humanistic, democratic, and liberal values in the social discourse in Israel. I'm Dalia Shenlin.
And I'm Gilad Halpern. Every week we'll be talking about books and research and other things that have caught our attention. Our guest today is a professor of law at Emory University, specializing in religious law. He was ordained as a rabbi from Yeshiva University and has served as rabbinical judge on the bench of Bet Din of America. He is the author of several books, most recently of Sharia Tribunals, Rabbinical Courts and Christian Panels, Religious Arbitration in America and the West, that has just been published by Oxford University Press, and we'll be talking about it today.
And basically we'll be asking him whether religious courts can be trusted to take over or fill in for secular American judiciary. Professor Michael Broyde, welcome to the show.
It's wonderful to be in Israel, and it's wonderful to be interviewed.
Thank you. I want to start with some of the background to how you came to this topic, not so much your personal background, but the American legal background. I mean, I think to understand the story of the rise of religious arbitration, we have to understand the rise of extrajudiciary alternate dispute resolution to begin with. Why did this develop into a fully fledged and elaborate system outside of the courts over the course of the 20th century?
Well, I guess we need to start 100 years ago. 100 years ago in the United States, there was no arbitration at all. You could neither select a different law nor a different court. This was part of the basic view in the United States and also in the common law from which the United States and Israel comes from, that law was truth. And just like we couldn't do physics by pretending that 2 + 2 was 5, you couldn't do law by agreeing to a different legal system. And since you couldn't agree to a different legal system, you couldn't agree to arbitration. In 1925, the United States Congress fundamentally moved away from this view and passed something called the Federal Arbitration Act, which mandated that when two people agree that they wish to be governed by arbitration, courts have to allow that arbitration. And over the past 100 years, the courts have consistently expanded arbitration to permit two things that are similar but different, and together are very powerful. They allow me to choose the law that governs our dispute if we both agree. And it allows the two of us, when we have a dispute, to choose a court that we want to go to, both another jurisdiction, like the courts in Italy, or a private arbitration. So between the two of these provisions of the Federal Arbitration Act, Congress essentially said that if you and I have a dispute and we agree that our dispute should be governed only by Italian law and only by judges who are sitting in Poland but trained in Italian law but speak French, and we agree to this and we sign a contract to that effect, the courts will enforce that agreement because we are entitled to resolve our disputes in any way we wish.
I see this as a very fundamental change in American law and society. I mean, to my mind, it's a radical shift. Why is it so controversial? I mean, you explain that there's pros and there's cons. Why is the concept of an alternative system of dispute resolution controversial?
Well, I would say that there are three controversies. One controversy is the general controversy of, is our legal system right? And then every other legal system shouldn't be used. This is weakest in the United States. In the United States, because it's federalized, something that's very foreign to Europeans and Israelis, really doesn't have a law. We have 50+ laws, and the law of every state differs enough that we don't really have a strong conception of law as truth. And Congress in 1925 made it clear that law is contract. And thus, just like you and I can live in New York but agree that California law will govern our dispute, even though we have nothing to do with California, but we like it out there, so too we can agree to have French law Or we can agree to be subject to some other legal system that we arbitrarily created. So Congress moves diligently in favor of law as contract and leaves pristine law to something that governs only interactions where we don't agree in advance, like a car accident. People rarely agree to a car accident or to be a victim of medical malpractice. Nobody says, yes, I want medical malpractice. Nobody says, I want a car accident. But people do agree on lots of commercial matters to what to do. The second thing that makes this of dispute is how organizations have moved into arbitration that Congress originally never imagined. This book is about how religion has moved into that space.
So it wasn't the original motivation of the lawmakers. I mean, they didn't want to reinvent religious law in any way in America.
I would say as follows. It's very hard to guess what's on people's minds. I think that Congress really thought that whatever two people want to is fine.
Or whatever the parties want.
Right.
As somebody once said recently.
Congress didn't think that there would be religious arbitration because it didn't dawn on them. But had you asked them, what about an agreement to be governed by religious law, I think they would have said, whatever the parties want is fine. And the third question is, how voluntary are these agreements? Everybody's more or less comfortable when the agreements are truly voluntary. So when Microsoft fights with Apple, and they enter into a contract to settle their agreement, we really don't have any deep moral view because Apple's a big company and Microsoft is a big company. And if they both agree that they want their disputes resolved by Polish law, we don't care. Sometimes in interpersonal disputes, we worry that people agree to things that they really don't understand or they really didn't voluntarily agree to.
Or didn't know they really had a choice.
Or didn't know they really had a choice. That's a way of saying, I didn't really agree.
Can you give us an example?
So there are a few ways that agreements that appear voluntary are really less voluntary. One of them is that when you live in a social community where everybody's doing this, my view is that so long as you're free to leave the community, that's still voluntary enough. I know other people are less sure of that. I'm pretty sure that if you want to live in a community that has these sets of rules and you're free to leave, then your decision to agree is voluntary. But I understand the other view. Sometimes, of course, you encounter agreements where the people simply don't understand what they're agreeing to. Like when I come to the airport here and I sign my rental car agreement, and I don't speak a word of Hebrew. It happens that I do, but if I didn't, I would simply sign and be agreeing to waive my rights that I really don't understand. A few months ago, I rented a car in Poland. I signed a Polish rental agreement. I don't know what it contained. I'm sure it contained an arbitration provision, which I couldn't read, and I waived my rights. So that would be an example.
But if that contract contained some sort of provisions that violated your, civil rights or human rights, then you would be able to take it to court. And court, probably in a liberal democratic country, wouldn't recognize it as a waiver in and of itself.
Right, but here's the problem. In the real world, arbitration panels only do one thing. They take away your money. Of course, everybody agrees that if I sign my Polish car rental agreement and the agreement says if I damage the car, they can poke out my left eye, no court would enforce that because that would be a terrible, gross violation. But in the real world, my ultimate right, which is not viewed as fundamental, but which really is the right not to have you stick your hand in my pocket and take my money. We all understand, of course, when an Islamic court says misconduct occurred, so the parties should be beaten, that's unconscionable and will never be enforced. But in the real world, what happens is that you're oppressed by the threat of poverty, not by the threat of a beating. So the central question is how much discretion are we going to give arbitration panels to take away your money?
Is there going to be any kind of oversight from the authorities? Is there any kind of relationship between these two rather independent legal spheres?
So in the United States, and really in all Western democracies, there's three strict restrictions that run all the time. The first is making sure that people have voluntarily signed. That's an entry obstacle. You can't agree unless you really agree. The second is an examination of the remedy to make sure that the remedy is reasonable. No beating, no poking out.
What does
people's
reasonable
eyes.
mean? Does that mean that it can't violate your human or civil rights?
Sure, but in the real world, it's so rare to encounter an arbitration panel that does anything unreasonable. If they're doing something unreasonable in that way, it's because they're newbies and they shouldn't really be in the business.
And would you say that what you're saying now characterizes general, including secular, alternate dispute resolution and arbitration, and religious arbitration?
Absolutely. There's no real distinction between how we review secular arbitration and how we review religious arbitration. And the third review is to find out whether what the arbitration panel has ordered is a violation of public policy. Sometimes countries in different times and different places have policy rules, and we simply don't want to let people contract out against them. In the United States, racial discrimination is violative of not just the law, but of the public policy. So even if we all agreed that you would be employed here, but I would be entitled to discriminate against you because you are an African American, and you agree to accept that discrimination, the courts in the United States would void that provision as violative of public policy.
Maybe now you can go back and tell the story that your book is really about, which is the rise of religious arbitration. Why did this happen?
So religious arbitration is taking place in the United States because the religious communities have lost basic faith in the secular legal system. As the secular legal system moves from its historic Judeo-Christian roots to being much more robustly secular. In the last 30 years, we've watched a huge evolution of the legal system in the United States from fundamentally grounded in religious principles. I don't mean by religious principles you should keep the Sabbath. What I mean by religious principles is the basic outlines of Judeo-Christian ethics to a much more robustly secular model of ethics.
Can you give an example of
Sure,
a
same-sex
landmark?
marriage. Same-sex marriage is a classic example where the more you belong to the Judeo-Christian ethic, the more you look and say, this is unimaginable. But there are many, many, many examples where our American legal system has moved to a model of secular ethics, which isn't necessarily bad at all.
I have to challenge you on a couple of these points because there are some sort of categorical statements here, I think, or a sweeping statement. For example, how do you measure that the religious communities of America have lost faith in the legal system? I mean, you point out the data. You refer to the Pew surveys showing that there may be a rise in the number of people who are unaffiliated, but we still have about 78% of Americans who identify with some religious tradition. Can you really say that 78% of Americans don't place faith in the courts before we even get to the example?
It's not about the courts. It's about the law. And even more particularly, it's about the family law. And of course, it's not 78% because in the United States, religions diligently divide between what we would call liberal and conservative. It's about 30%. But
who are conservative?
Who are conservative, what we would call. And they're slowly opting out. Now, of course, trends in American law change, as we sort of have seen the change in the last 5 years. But the revolution that was heralded by same-sex marriage has caused the evangelical Christian community to say American family law is not for us. But once you say family law is not for us, so then you have to craft an alternative legal system that governs your community's family law.
What was it about the family law that wasn't for them?
I would say it's basic doctrines of the following idea is the norm in the United States. In 1980, New York State, in a case called Onufry, a quite famous case, said as follows: all sexual activity that's voluntary, non-commercial, done in private, and between consenting adults is fine and proper. So that model has essentially caught on in the United States and has been endorsed now repeatedly by many different courts, including the Supreme Court. The rise of sexual liberty.
Probably Roe v. Wade, too.
You don't have to think about abortion in that way. You can, but
you don't think it's something that's alienated that 30% who are conservative, religious, evangelical, or Christian
it could
and conservative?
be, but Roe is a case about free choice. It doesn't really force me.
Do you think that's how they see it?
Many do.
It doesn't seem like it from how vociferous they are about trying to have it repealed.
Time will tell.
Negated.
But a much more common case is as follows. Two people marry and they agree to be evangelical Christians in their life. And they conduct themselves that way. And one of them at the age of 45 changes their mind and wishes to become secular and leave their community. Should there be a penalty for that, and what should that penalty look like? So secular courts validate sexual choice even after you're married, and don't impose, for example, a penalty on adultery. They perceive adultery to be a right that adults have, independent of their spouse and independent of whether they agreed not to do this. So if two people wish to enter into a marriage in which they agree that there is an adultery penalty, meaning the spouse that commits adultery loses 10% of the assets, that can only be done by a premarital agreement and an arbitration provision.
We have lots of questions here, but one of them is
Ask
that,
away.
yeah, I mean, you do talk about this shift that American law has become less, rooted in its religious traditions, although I would challenge that because certainly, as you say, it's not based on any formal religious traditions, but the opposite. America prides itself on a separation of church and state, and then you follow that up by giving examples of these newer, more secular values. Specifically, you cite equality and fairness. That seems a little counterintuitive considering the first line of the Declaration of Independence is that all men are created equal. Let's leave aside men and women.
But having
why
said that,
why is that a new development? Isn't something like the recognition of same-sex marriages or increasing recognition of it, isn't it actually more of a fulfillment of the original values of American law?
It's not important in the following sense. If you construct law as contract, then when two people marry and they wish to construct their marriage different from the norm, is that okay or not okay? There are two answers to that question. You can say we have our values and you must follow our values, or we have our values and you are free to opt out. Congress in 1925 said in every area of law, although we have our values, any two people by contract should feel free to opt out. So it's not important to me whether same-sex marriage or adultery is part of the original values of the founders, because arbitration law recognizes when two people enter into a marriage and they agree to a different set of rules, whether these set of rules are historically part of America or not, is unimportant. It's that two people have the right to construct their law partnership, their medical practice, their radio station, or their marriage by any rules they see fit, including their obscure, weird, and unhappy religious laws.
No, I think the question is, what does it mean to say, well, American society has somehow created a situation where people are opting out of the fundamental values that characterize the law, such as equality and fairness, which I would argue is a fundamental value of the American common society. Are people not just opting out of that? Not just the same-sex marriage debate.
But you see, to me, when you focus on the values of arbitration, it's not important whether these are right or wrong values. Two people own a business together and they own it.
Wait, it's not important whether equality is a right or wrong value in American life?
Because contract law trumps values. That's what's important.
So if people agree to an inequality in their approach,
then our legal system validates that. It's so important to understand. The opponents to arbitration say we shouldn't permit that. But arbitration in the United States has always been predicated on the fact that when the two of us enter into a business agreement and our business agreement says we agree to inequality, then our legal system should validate that agreement.
But doesn't it open the door to great injustices? I mean, if, say, I don't know, men and women, right? Patriarchy in traditional societies, which is something that is a very palpable phenomenon all over the world. I mean, that might be a good segue into discussing Israel and other countries with established churches and how that plays out, which will be the topic of your next book. But if there's a powerful man and a less powerful woman who, and that brings us back to the concept of volition and consent, enter into this contractual agreement that waives some of their rights, the less powerful party will inherently have to waive a greater deal of their rights than the more powerful one. So by endorsing this kind of arrangement, don't you also endorse injustice?
So you've constructed a model in which you think you have justice and you wish to impose it on people against their will. I don't have a problem with that approach. It's anti-contractarian, meaning you deny the right of people in power imbalances to sign a contract that they both agree and understand because you look at it and say, I don't like this agreement. I understand that view. It's not a ridiculous view. It creates an overarching legal system in which truth is imposed on people top down, even though both sides in the contract don't want it.
Well, you're assuming there's total free will within a traditional society that typically, especially because we're talking about religious courts, most Judeo-Christian religions and most religions in general favor male power over female powers. Isn't it the case that the more you encourage, and your book does call to encourage the growth or allow the growth and nurture the growth of these religious courts, isn't that also essentially strengthening religious traditions that in turn strengthen the patriarchal power dynamics?
I'm not sure, because I believe that people read contracts, live in a free and open society, and leave when they want to. Meaning it's so important to understand, since there's a signing moment, the people who don't like what they sign walk away. The exit rights are extremely important in any just legal system. But what you're denying is that some people like living in power imbalanced societies, and you're going to take away their freedom to structure their life as they see fit.
Okay, what about Israel, where they don't have a choice?
Good.
Right?
Now,
Oh, great. You're trying to get out of this complicated question by asking a simpler question.
The answer should be a lot simpler in this
So
context.
when you deal with a society in which there's an established church, my thoughts are much more tentative. Because, honestly, I haven't fully finished thinking this through.
That is a very honest answer. I like that answer.
When you talk about religious freedoms, there are two different kinds. There's established church and there's free exercise. So if you look in England, for example, rather than Israel, but Israel is really very similar to England historically, you have an established church but religious freedom. You can have a society like France in which there's no established church, but there's no religious freedom. You can have a society like England in which there is an established church and there is also religious freedom. In the United States, there's both no established church and robust religious freedom. The central question in societies like Israel is not whether there's an established church. It's what are the parameters of the freedom given to people who don't wish to be part of the established church. Israel has yet to well work that out, and things are thus in extreme flux in Israel. Not because the established church is not clear, but because the parameters to deviate are not well established. You can imagine a society like England, which has a firm established church, but robust deviation rights, which don't diminish the established church, but allow people to say, it's nice that that's the established church, but I don't care.
But isn't this deviance part of, a broader structure of secular law?
Well, so let's take England as an example. The religious courts in England, like the religious courts in Israel, have subpoena power. And if you engage in contempt of court in an ecclesiastical court, you can go to jail, something that would never occur in the United States. So there's some truth to that. The rabbinical courts in Israel, like the Muslim courts in Israel, like the Church of England courts in England all derive this power not from some Jewish structure, but from some British structure. So I'm not sure how this works in Israel, and I'm not sure how it works in all established church communities, because you have highlighted the basic difficulty, which is the basic freedom in America is I say to my church community, goodbye. It's nice that I grew up here, but I wish to leave. And the exit from churches, like the entry, is very high. People make choices in America about their own religion much more than in any other Western society. Conversion, in and out, obviously in and out, because when you convert in, you convert out, is a much more common phenomena in America than it is in Israel. That's an important comment. Exit rights are fundamental freedoms.
I have to go back to the sense of the role of law in creating a common, shared basis of society. This is a critique that you do address in the book. I mean, I'm not suggesting we roll back the rights of arbitration, but I still wonder if actually encouraging, which you advocate in the book, means continually undermining the basis for a shared experience, a shared set of values, ultimately a shared community. And in general, we're witnessing a period of a lot of fragmentation. Doesn't this contribute to that fragmentation and the weakening of the social fabric of American life or any other country that would do this?
Yes. And I'll go further. There are two models running in America. There's the melting pot, and there's the multicultural salad. You have endorsed in conversation right now what we call the melting pot.
I've asked a question about it.
Which is we've all come in different, and we all get melted into one flavor.
Well, if you think the law, sort of steamrolls people's identity, which obviously it doesn't because America is a very diverse place.
Well, but you see, there's two measures of diversity. One measure of diversity is where do you come from? And the other measure of diversity is how capable are you of maintaining your diversity? I like the multicultural salad in which we all participate in the Commonwealth as it interests us and benefits us, and we all deviate when we want to. The whole is made up of many different distinct parts that have kept their own identity. So in a salad, you can see the tomatoes. You can see the lettuce. We're all different. We all get along well together, and we have certain common values. The biggest common value is the state has the unique monopoly on police power. Nobody uses force or violence other than government.
Other than everybody because they have a constitutional right to bear arms.
No, I don't think that that's a reasonable description of the United States.
Okay.
I think that what happens in the United States is the police are the monopoly on lawful power. But again, it's the police are the monopoly on lawful power. And arbitration becomes a way that all the tomatoes get together and enforce tomato law when they like it. And that this is true, to give you an example that we're all much more comfortable with, which is union rules are essentially arbitration. That's what they are. When we say in Israel, the Histadrut, the Labor Federation.
I think most of our listeners probably.
The Histadrut, the Labor Federation.
Main Labor Federation.
The Labor Federation has its own narrow courts that enforce labor rules. These are arbitration agreements.
What about the mafia? They have their own courts.
So the mafia is out because they don't accept the limitation on power and violence.
And what about the identity politics problem? I mean, doesn't this kind of thing basically reinforce the notion of or monochromatic identity and say, it encourages the growth of communities that say the law is purely based on your religious or ethnic identity. It's different from labor negotiations or other private sector business negotiations. We're talking about people's very identity.
Well, so yes, it does. I think that's the salad metaphor, which is that some of the tomatoes only want to hang out with tomatoes. And our legal system recognizes that the railway workers can agree to a set of rules that only govern railway workers. And those Catholics that want to can agree to only hang out, particularly in family law, with only Catholics. And that we recognize the unique construct of family is different from commerce. There's a great deal of hostility in the United States to my opening a general business and only doing business with my co-religionists. But just to give you an example, it's a very important example. When I take out an ad looking for a lawyer, I can't say I only want a Jewish lawyer. Can't do that. But when I take out an ad looking for a spouse, our legal system recognizes my right to engage in social, ethnic, and religious discrimination in spouse shopping in ways that I can't and that I shouldn't, and that's illegal to do in lawyer or doctor shopping. We have a greater sense that family is entitled to homogeneity, and we even allow discrimination in spouse selection along social, cultural, ethnic grounds that we would never allow in any other area.
Is that enshrined in the law itself, or is it the spirit of the law?
No, that's really enshrined in the law itself, because Title VII doesn't really govern these kinds of interpersonal connections. That's why newspapers will publish personal ads that make mention of the fact that I'm looking for a person of a particular ethnicity or type or gender. I can't say I'm looking for a lawyer, but I'm only looking for a female lawyer. But I can say I'm looking for a spouse, but I'm only looking for a female spouse. We recognize that family is narrower.
I think the last question that I would really try to raise in this context is that you're not only saying we should allow this kind of ability to develop these different identities and different tomato laws. What you're saying is the government should encourage it.
I'll go further. I think actually tomato laws are good for the United States so long as we diligently make sure that everybody who signs them voluntarily knows what they're getting into, because they're very efficient. It's very hard for courts to adjudicate tomato disputes because they don't really know tomato law. It's very hard for courts to adjudicate railway disputes because they don't really know railway law. It's very hard for the courts to adjudicate Jewish disputes or Catholic disputes because it requires a level of expertise. So when I sell you kosher meat and we have a disagreement about whether this meat is really kosher, it's true, secular courts will determine that, but it's very hard for them, and they tend to make egregious mistakes in determining what narrow religious words mean. And it makes much more sense that when you and I sell each other kosher meat, that we should agree to go to a rabbinical court, which has a much firmer grasp on the nuances of what we'll call co-religionist commerce. So yes, I think it's efficient, and that it's cheaper, faster, and more accurate to allow religious arbitration tribunals to resolve these disputes than it is to drag them into court. Although I agree the courts can do it, I just think they do a less than good job.
Although maybe we should also agree that a marriage and two people's lives are different from kosher meat.
Of course, that's
We
right.
agree?
That's why I think that when people get married, the most important thing they do is they sign an agreement that sets out the rules governing their marriage. That's a different interview, but an important one on the rise of prenuptial agreements throughout the United States. With such diverse models of marriage, you need prenups to make it work.
All right, something to look forward to. Our next interview, Professor Michael Broyde, a legal scholar at Emory University, specializing in religious law and the author of several books, most recently of Sharia Tribunals, Rabbinical Courts and Christian Panels, Religious Arbitration in America and the West. Thank you very much for coming in today.
Thank you very much. It's a pleasure to be here.
And also big thanks to Gizem Ozdemir, our sound engineer, to Itai Shelem, our producer, and to the Van Leer Institute for the generous support. We would also like to thank Peter Frey and Carrie Shapiro and the Romay Foundation, who made a very generous contribution to the Tel Aviv Review. And now we have a great opportunity for you too to help us survive. Go to our website, www.tlv1.fm/Tel Aviv Review, and donate to our Patreon campaign. It's a new crowdfunding campaign to help us survive. You'll be part of our quest for learning and knowledge, plus you get gifts and all sorts of perks. Many thanks to those who already have donated.
From me too.
Yes, from Dahlia as well. And today's episode will be complemented by extra segments for contributors. You know who you are. In the meantime, don't forget to check our archives. There are more than 400 interviews to keep you busy, entertained and annoyed. Like us on Facebook. Our page is called the Tel Aviv Review Podcast Ideas from Israel. And follow me and Dahlia on Twitter. Join us again next week for another edition of the Tel Aviv Review. And until then, goodbye.